Is Bret Schnitzer here? My eyes are so bad. There you go. Come on up, Bret. We have, we save this for last because it seems to be a real popular part of the program where we talk about some cases where our brothers and sisters have done real well at trial. And we have two examples today where we're going to finish up the day with. We have a great verdict that Phil Serafini had, another one that Bret had. And without further ado, Bret, you're going to go first? Do it, babe.
Sure.
All right.
Thank you. Good afternoon, ladies and gentlemen. I'm going to start by saying that in terms of victory in a jury trial, it doesn't get much better than this one in my mind. The defendants, this was a first party and an uninsured motorist case, and defendants offered zero. And I've been doing personal injury law for almost 30 years, and this is the first case I've ever had where the defendants offered me zero. They offered zero throughout the litigation. We had a 2-week jury trial in front of Susan Borman. They offered zero throughout the entire 2 weeks up until the last day. And now they owe in excess of $350,000. So I'm going to go into the defenses that the insurance company used in this case, which were ever-changing. Their offer was not ever-changing, but their defenses certainly were. The first defense that the defendants used in this case was what's called a garaging defense. A garaging defense is basically where an insurance company claims that there was a fraud in where the residence of the person who took the policy out was, and that they want to void the policy out. And in this particular case, my client, the owner of the vehicle, who was not my client, lived in Southfield with his mother and had a girlfriend in Detroit. And the insurance company took the position that he actually lived in Detroit. And so they sent out what's called a reservation of rights letter. I'm sure most everyone has seen that, to all the occupants of the vehicle. There were 5 occupants in this vehicle, saying that we are reserving rights to paying any PIP benefits because we believe that there was a fraud in the application for the no-fault insurance policy. Now, when the client came in with that reservation of rights letter, my client wasn't the person that took out the insurance policy on the vehicle, so that reservation of rights letter was technically incorrect. A garaging defense is only applicable to the person that committed the fraud in taking out the insurance policy. It doesn't apply to innocent passengers or people that didn't have any involvement in taking out the policy. So I sent a letter to the insurance company and indicated to them that their only garaging defense would apply to the person that took out the policy. And after a couple months, I got a call from the adjuster who said, yeah, we spoke to our legal department and you're right. That garaging defense doesn't apply to your client who didn't take the policy out. Now, in the meantime, the insurance company had canvassed the neighborhoods as they do, trying to establish that my client, or that the owner of the vehicle took the policy out, lived in Detroit rather than Southfield, and apparently that effort failed. They were unable to establish that. But that didn't stop them. The next defense that they gave, and this was in a letter, is they sent a letter to my office on behalf of my client, indicating there was no independent verification of motor vehicle accident occurred. And to understand this letter and the absurdity of it, I guess you'll have to understand a little bit about this particular case. My client was at a party in the wee hours of the night in the city of Detroit. And there was a need to go and get more libations, alcohol, and et cetera. And so my client, who's a non-drinker, was designated as the designated driver for the run to the liquor store. There were 5 people in total in the vehicle, my client driving. The rest of the people were intoxicated, so they didn't drive, including the owner of the vehicle, who was now a passenger. On the way to the liquor store, they were struck from behind at a red light by an unidentified vehicle. It was either a minivan or a truck, which hit them with such impact that the tailgate of the vehicle my client was driving, which was a 26-year-old pickup truck, popped right off of the back of the vehicle. It broke the rear tail light of the vehicle. There was debris all over the roadway. The vehicle was damaged. So my clients called the Detroit police and asked them to come out there to make a police report. Well, they waited about, and this is in the wee hours of the morning, they waited about 30 or 45 minutes. A scout car actually went by them. They tried to flag it down, it just kept going, so apparently it wasn't for them. And so they decided, we're not going to just sit here all night. We're going to go to the precinct and make the police report. So they went down to the closest precinct. They made a police report. The police report indicated the damage. They had the truck there at the police station. A police report was made. The next morning, my client's having neck and back problems, which she had never had before. And she goes to a local doctor in her neighborhood. She ends up getting referred out for an MRI, and she has a herniated disc. And she's treating. So this letter that there was no independent verification of a motor vehicle incident was very suspect. And we filed suit. During the litigation, obviously depositions were taken, and I scheduled the deposition of the claims adjuster who had sent the letter, and she was the same claims adjuster that had been assigned to the claim throughout the litigation, throughout the pre-litigation. And I asked her a series of questions such as, what does this mean, no independent verification of a motor vehicle incident? I mean, by the way, they took witness statements of every single person in that vehicle. So they had 5 recorded statements that they took before anyone had any lawyers. I said, what do you mean by that? I said, you have recorded statements from every person that was in that vehicle indicating that the collision occurred. Isn't that independent? You know, hemming and hawing. Eventually, she agreed. You have medical treatment where you have medical treatment where there's a consistent history that it was related to the motor vehicle incident. My client had no prior neck or back problems. Isn't that independent? Yeah. You have they took photographs of the vehicle, of the truck with the bumper missing from the back, or the tailgate, excuse me, and the broken headlight. Tail light. Isn't that independent? Yeah. On and on. But yet she sent this letter, and I said, well, what does this mean? She says, I don't know. I said, what do you mean you don't know? Isn't this your signature here at the bottom of the letter? Yeah, it is. Well, how could you not know? You signed it, didn't you? Yeah. Well, someone higher up told me to write the letter that way. And I said, well, who's that? Well, I'm not sure. But one of my superiors told me to write the letter. And you didn't understand what the letter meant when you sent it? No. Okay. So even in light of that deposition testimony, still a 0 offer. We're still moving towards trial. So I filed a motion for summary disposition on the PIP aspect of the case, arguing to Judge Borman that there was really no material dispute not to pay no-fault benefits. I mean, there were admissions from the adjuster. There was all this independent evidence. There were photographs of the damage. There was a contemporaneous police report. There was medical treatment. There was no prior history of back problems by my client. And after I filed the summary motion, which most of you who've been in front of Judge Borman know that she's pretty strict with her scheduling orders, the defendants hired an accident reconstructionist out of Ohio by the name of Dale Dent. And Dale Dent is an interesting fellow. His foundational background as an expert is as follows. He went to college for about 1.5 years on a football scholarship at a university down in Ohio. He was injured. Oh, he was studying education. No science, no engineering, no biomechanical schooling, no physics, no mathematics. Studying education, which is fine. He gets injured in a football scholarship and decides he's going to drop out of school, which he does. Then he bounces around for a couple different jobs, ends up as a police officer for a couple years, number of years ago, 20, 25 years ago, claims he did some accident reconstruction, took the classes at one of these schools where you can take 25, 30, 50 hours of accident reconstruction seminars, and now he's an accident reconstructionist. And the other interesting thing about expert Dale Dent was that he wrote a approximately 15-page report the same day he was retained by the defendants, and they had to hurry up and get his report out because they wanted to attach it as an exhibit to respond to my summary disposition motion. So the same day that he is retained, he's got a 15-page report. And the only physical evidence he has to substantiate his position, other than the statements that were taken by the insurance company, is 3 photographs that the insurance company took of the back of this vehicle where it was sitting after the motor vehicle accident. And the photographs show the bumper broken out, the rear tail light broken out, and the pickup truck part is detached. And so he comes up with this opinion that the accident could not have occurred in the manner that my plaintiff had testified it did. So this is defense number 3. Accident never occurred. So we've gone from garaging defense, that they can't substantiate, no independent verification of a motor vehicle incident, which they were just blown out of the water on, and then they go to accident never occurred. So this is apparently a fraud. We tried the case, we took the defendants took the accident reconstruction as dep by video because he had some conflict. And after about 3 hours of cross-examination, I got him to admit that the accident could have occurred in the manner in which the plaintiff testified it did. And I blew it up as a big exhibit for trial. In addition, the cross-examination about his limited qualifications and even whether he met Daubert. Nevertheless, can't settle the case. The judge let us retain an expert. We retained Harold Josephs, who's from Lawrence Tech, very qualified expert. Which we have to try the case now. The judge bifurcates the case into 2 parts. The first part, the jury's going to decide whether an accident occurred, because I think the judge believed that if the jury said yes, they'd pay us. If the jury said no, case would be over. So we tried the first part of the bifurcated case for a week. The jury comes back after 5 minutes and says, yeah, an accident occurred. Judge calls us into her courtroom, for her chambers, for a whole day. Their offer is 0, even though this was their entire defense. So we want to try the case on damages now. They got no DME because they put all their eggs in the one basket, and they still aren't going to settle the case. So we tried it with three experts. I brought 2 live doctors and I did a video dep of the pain management doctor, plaintiff, and a couple other witnesses. Another week in front of Judge Borman. At the last day of trial, we played the videotape of the pain management doctor. And defense counsel had to sit right next to the jury, as did I, so we could watch the big screen there. And the defense attorney had obviously argued serious impairment, defense number 4. And then he starts trying to cross-examine the doctor on causation. And he says to the doctor, now the plaintiff is a morbidly obese person, isn't she, doctor? And the doctor's like, and she does, believe me, this plaintiff, she's not twiggy, but she doesn't look morbidly obese. She just looks like a normal person out there in society. And the doctor's like, no. And he said, well, she's morbidly obese, and morbidly obese people have back problems, despite the fact she never had a back complaint up to the date of the incident. And doctor says, no, sometimes morbidly obese people have knee problems, but I don't see them with back problems, and she's not morbidly obese. Well, when he's asking these questions, and he's very aggressive with this doctor, that jury is moving around, and you can see they're visibly upset. I mean, and after that deposition, they started, and then which was the last day, as soon as that dep was over, him and his claims adjuster, who allegedly had was holding the purse strings and had the ability to settle this case, ran out in the hallway for one purpose and one purpose only, to try to get authority to settle the case. And at that point, almost done. At that point, They offered 6 figures, but it wasn't enough. The jury came back and gave $189,175 in the UM portion of the policy. There was a $250,000 uninsured motorist portion. They gave every dime of medical, which was about $45,000. They gave all the household services, and they gave penalty interest, which allowed the judge to award attorney fees and case evaluation sanctions, because we beat case eval. And so the total verdict is in excess of $350,000, and they're paying. They've also been ordered to pay $285 an hour for the appeal, which we're currently in. Thank you.
You know, at the end of the day, and I'll try to be brief, although this is a funny case, and it can, frankly, you could be amused by the ridiculousness of AAA's position throughout. I had a case with a 5-year litigation on a PIP case. Went on for 5 years. I filed it in 2007. I tried it to verdict in April of this year. I'm kind of glad that Mr. Seifert left, because then I don't have to tell you that I don't have to disclose worry about disclosing the insurance company and what I think about this whole business. But the end result is my guy's driving a pickup truck. He has an 18-wheeler pulls out in front of him while he's driving down the highway, what's called the highway, but it's actually a surface road, doing the speed limit around 45, 50, parks it into the side of the 18-wheeler. The actual cab of my guy's pickup truck is shifted off the frame. That's how hard it hit. He ends up, he's a kidney dialysis patient. It's 5 in the morning. It's icy outside. He's going to dialysis, driving himself that day. So what happens is kidney dialysis patients is what is a prologue, or again, I'm going to give you a little tease. They're subject to infection. There are a lot of problems. And so he ends up going to the emergency room the next day. He's in a lot of pain, complains of back pain, neck pain. A couple days later, he goes to the emergency room again, ton of pain, back pain, neck pain. Ends up treating with a chiropractor primarily. This accident is in February 2006.